Hi, greetings. It's me, Dr. Paul Gerhardt, and today I want to talk about the public sector, labor relations, history, and laws. So this is kind of a comprehensive video. Specifically, we're going to talk about history of the public sector, what the public sector is, labor relations, public sector labor laws, public sector unions. We are going to be contrasting public and private sector labor relations, current public sector challenges. And I want to start with the Memphis sanitation strike. This is when African American sanitation workers went on strike in order to be paid minimum wages. So things start with a movement. People get together, they recognize things aren't the way that they feel that they should do, and then together they create change. Who can blame them? Any group of people who are unhappy really needs to recognize that they have the ability to help create change. So let's define the public sector. The public sector really consists of a myriad of different levels of jurisdictions, governmental units that are all about providing basic services. There are essentially three levels of government: federal, state, and then local. And we'll talk a little bit about that. All three levels of government have two roles as it really relates to collective bargaining. One in the private sector as a creator and protector of collective bargaining rights, and then in the public sector as an employee, or employer, The federal government is divided into three main branches: legislative, judicial, and the executive branch. And with Congress, which is called the legislative branch, that's the one that passes the actual laws. So let's talk a little bit more about the federal government. The president is the elected chief executive officer and is charged with faithful execution of the laws. And then the Supreme Court and all other federal courts have judicial authority vested in them by the Constitution to interpret the law. With state government, there's a governing body in all of the 50 states, and the state governments and federal governments are all legally dual sovereigns. And so dual sovereignty is the sharing of governmental power between federal and state governments. And under the U.S. Constitution, all powers not granted the federal government are reserved for the states. So with state government, there is shared power with the federal government, as I mentioned, and under the U.S. Constitution, all government powers not granted to the federal government are reserved for the states. All states have a written constitution and a three-branch government modeled on the U.S. federal government. The executive branch of every state is headed by an elected governor, and the legislative branch is made up of a Senate and a House of Representatives, and the judicial branch is headed by a Supreme Court, which hears appeals from lower state courts. So state governments kind of mirror the national government, so to speak. A municipal corporation, and so we're talking about local governments, is the legal term for a local government. So municipal corporation. And then a municipal corporation is a political creation of a state that is composed of the citizens of a designated geographic area in which performs certain state functions on a local level. And then the state gives municipalities the power to create an official governing body, such as a board or a council. So let's continue to talk about local government. There's something called a home rule. and that's a flexible grant of powers from the state of municipalities to determine their own goals without interference from the state legislature or state agencies. The governmental authority most commonly exercised by municipalities is the exercise of what's called police powers, and the power to enact laws governing health, safety, morals, and general public welfare. So, a little bit about the history of the public sector and labor relations. There's something called the Pendleton Act, and that was created the federal merit system to address the abuses of the spoils system, administered open competitive examinations, protected employees from being fired for political reasons, and provided that Congress set the wages for federal workers. So that's the Pendleton Act. Two early federal employee organizations in the New York Letter Carriers, 1863, and the National Association of Letter Carriers, 1890, engaged in intense lobbying for improved salaries, better working conditions, and greater security for letter carriers and families. There was a push for public sector collective bargaining during the 1930s and 1940s. Private sector unionization continued to flourish under the protection of the National Labor Relations Act, and unionization grew later and more slowly than public sector for a number of reasons. Unions held less attraction for many public employees because they already enjoyed some of the protections sought by private employees. The nature of the government employment was predominantly white collar, while unionization in the 1930s and 1940s was and large blue collar activity. The legal environment that was highly unfavorable to public employees, collective bargaining, kept employees at all levels of government from being able to approach government employers and engage in collective bargaining. The Hatch Act, passed in 1939, was amended in 1993, and the Hatch Act limited the political activities of federal employees to shield workers from political pressures and ensure that the resources of the federal government were not used to favor a political party. The Sovereignty Doctrine says that unrestricted and paramount power of the people to govern. In the public sector, this doctrine is represented as a basic reason for not allowing employees to have collective bargaining rights or the right to strike their public employers. In 1962, there was an executive order from President John F. Kennedy, which allowed federal employees bargaining representation, forms of employee recognition, and the right to collective bargaining. And in 1970, the Postal Reorganization Act of 1970 came around, and it was an initiative of the Nixon administration, and it passed the Postal Reorganization Act of 1970 that made the U.S. Postal Service, USPS, an independent agency of the executive branch. And the Civil Service Reform Act of 1978 was designed to reform the outdated federal civil service structure modeled after the NLRA, created the Federal Labor Relations Authority to oversee labor management relations within the federal government. The National Security Personnel System, or the NSPS, was to oversee about 760,000 federal government civilian employees. And the union successfully objected in court actions to change the labor relations sections of the NSPS. So there are a lot of federal public sector collective bargaining acts that came out between 1871 and 1993. We're going to talk a little bit about state and local government employees a little bit more. There's no federal law currently governing the collective bargaining relationships between states and local governments and their employees. Comprehensive laws allow state and municipal employees to join unions and to collectively bargain with their governmental employer. With state and local government employees, there's targeted collective bargaining laws, either that grant rights to most states or local employees. There's restrictive collective bargaining rights, either that prohibit public sector collective bargaining or are silent on the subject. Local, county, and municipal governments may adopt collective bargaining laws or by practice recognize and bargain with employee organizations. There are lots of states that have comprehensive employee collective bargaining rights. Washington, Oregon, and California are some of the major West Coast states that have comprehensive rights. So it's kind of interesting to see how different states allow collective bargaining. With public sector unions today fall roughly into three categories: associations or fraternities, public sector only unions, mixed unions, and then many public sector unions have their roots in professional associations and fraternities that developed before widespread public sector collective bargaining. So with collective bargaining in the private sector, it's largely shaped by market forces. And collective bargaining in the public sector, however, is ultimately shaped by political forces. And the core difference is that the government really is not a business. So, in a nutshell, that's public sector labor relations, a little bit of history, and some of the laws. I hope that as you continue to dig deeper into the literature, that you get your questions answered and you think about the value of labor relations in every type of organization. There's got to be win-win outcomes, and employers understand the value of employees, and employees understand how their contributions make a difference in the organization. It really helps set the tone for creating those win-win outcomes. All right, I've given you a lot to think about, and I appreciate your time. Thanks for watching this video, and I hope that you have a great day, because only you get to choose how you feel about it. I'm Doctor.